Okay, hearings officer, we're ready to begin when you are.
Excellent. All righty. Good afternoon. We'll go on the record now. The time is about 1:28 on February 5th, 5th, right? 5th, 2026. This is a continued hearing for Deschutes County file numbers 247-25-00309-CU and 247-25-000-766-MA. My name is Greg Frank, and I am the hearings officer in this matter. Before we turn to particulars of this hearing, I would like to turn things over to Ms. Stewart from Deschutes County, and she will describe to you how this electronic hearing process works.
Good afternoon. For the record, my name's Audrey Stewart, and I'm an associate planner with Deschutes County. The item for the hearings officer is a conditional use permit for fill and excavation within wetlands and floodplain and a modification of application. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing. This will be followed by a brief presentation on the application. The county has established time limits for testimony as follows: 30 minutes for the applicant, 10 minutes for agencies, 3 minutes for the general public, and 10 minutes for the applicant's rebuttal. However, the hearings officer can modify or eliminate these time limits. When the testimony portion of the hearing begins, the applicant will present first, followed by agencies, next those in support, then those in opposition, and finally anyone neutral to the applicant's request will testify. Afterwards, the applicant will then be afforded an opportunity to present rebuttal testimony, and finally, staff can make any closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name, as well as your mailing address. For our in-person participants, if you wish to testify, please add your name to the sign-in sheet. I'll use this list to call up participants for their testimony. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or if called in using the Zoom dial-in option. When hearings officer Frank asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, or if you've called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you're in person, please submit your written testimony to me after your oral testimony. If you're participating remotely, you can submit your written testimony to me via email at audrey.stewart@deschutes.org. Hearings officer Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Any written or oral testimony that was previously submitted is still in the public record and does not need to be resubmitted. Anyone is able to provide testimony at today's hearing, and comments that were provided at the December 4th hearing do not need to be repeated. Are there any objections to the format of the hearing? If you're attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn the hearing back over to hearings officer Frank.
Thank you, Ms. Stewart. As Ms. Stewart described, we're following the normal hearing procedures in the Deschutes County Code, and I will provide sufficient opportunity for everyone to participate at the appropriate time. I'd ask your patience as we make sure we get through each of the steps she just outlined. The application is being considered through the quasi-judicial process, and I will consider only only factual evidence that is in the record. I'd like to repeat at this point in time, if you've already submitted evidence into the record or have already testified, if you aren't adding something new, you do not need to do that again. But if you wish to, I'm not going to stop you. All right. I will then apply the facts and law and any relevant provisions of the comprehensive plan and land use regulations in making my decisions. The standards and the applicable or relevant criteria to this hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report. The public notice and the staff report are posted on the county's website. They are also available directly from staff upon request. It is important that you direct all testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I strongly urge that you also explain why that particular criterion or criteria apply, and do so with specificity so that all participants may respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal that issue at the Land Use Board of Appeals. Also, the failure to raise constitutional or other issues relating to any proposed condition of approval with enough detail to allow me to respond to the issue in my decision precludes an action for damages in circuit court. As I just noted, I serve as a county hearings officer in this matter. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I'm obligated to remain impartial and do not represent the county's interests or interests of any other participant. To that end, I will state for the record, as I did in the original hearing, that I do not have any relationship with the applicant, and I'm not aware of any connections that I may have with other participants to this proceeding that would prevent me from remaining impartial. I have communicated with staff, but only to discuss the particulars of today's hearing, but not the substance. In other words, I've talked to the staff about scheduling for the most part. I do not have any ex parte contacts to disclose. It is my obligation to preside over this hearing in an efficient manner. And I'm just going to ask once again, although we did that in the original hearing, does anybody object to my participation as the hearings officer and ultimately issuing a decision in this case? If so, would you please let Ms. Stewart know either remotely or in person? Ms. Stewart?
Hearings officer, no one in person or online is raising their hand.
Okay, with that, then I'm going to turn it back over to you to give the, from what I understand, staff presentation. Go ahead, please.
Hearings officer. I'll now provide some background on the subject application. Today's hearing is a continuation of a public hearing that was held on December 4th. Following that hearing, the written record was left open until December 31st. On December 31st, the applicant submitted additional materials, including a modification of application. In response to these new materials, the hearings officer issued an order on January 13th to reopen the written record and continue the public hearing. The modification of application restarted the 150-day land use clock for this application. The new date by which the county must issue a final decision is June 1st, 2026. The materials from the initial hearing are in the record, so I won't repeat them here. As a quick overview, this request is a retroactive approval for fill and excavation within wetlands and floodplain for an expansion of a boat landing area. In the initial staff report, there was an interpretive question raised regarding whether this excavated area meets the definition of a boat slip. The applicant submitted a modification of application to provide an alternate argument that the boat slip is a lawful nonconforming use because it predates the adoption of the floodplain zone. On this slide, I've listed new approval criteria that would apply if the boat slip is a nonconforming use. If the hearings officer determines that the boat slip is a nonconforming use, this section requires findings regarding the nature and extent of the use. I want to note that 18120.010 F2 of Deschutes County Code states an alteration of a nonconforming use is subject to other applicable provisions of Title 18. Staff maintains an alteration to this boat slip is subject to the fill and removal provisions of 18128.270, whether or not the boat slip is reviewed as a nonconforming use. The staff report and supplemental memo contain historical aerial images of the subject property, and the applicant has provided materials that they'll discuss in more detail. The full record is available at the link here on the screen. And with that, I'm available for any questions from the hearings officer.
Thank you, Ms. Stewart. I'm going to defer my questions until the end of the hearing. This would be the time and the place for the applicant or applicant's representative. And as always, please identify yourself for the record, first and last name. Do it slow enough that I can actually get the spelling correct, and give us your mailing address, please.
Thank you. Good afternoon, Hearings Officer Frank. It's Chris Koback, K-O-B as in boy, A-C-K. The address is 937 Northwest Newport Avenue, Bend 97703. And again, I'm here on behalf of the Hanson Trust, the applicant. This one shouldn't take very long. We have no new evidence. The evidence was in from the open record period in the hearing, but as staff did an excellent job summarizing, there was an interpretive issue, and we filed a modification as kind of a belt and suspenders. The interpretive issue is whether this landing, which was constructed originally in the 80s on a man-made canal, qualifies as a boat slip under Chapter 1896 in the Deschutes County Code, specifically 1896-050. Boat slips are prohibited in the floodplain, new ones. But we put together a fairly extensive text and context argument for you in writing, establishing that a boat slip, which is an area excavated along a lake, river, or stream, does not, what we have doesn't meet that definition, because the man-made canal is not a lake, river, or stream. And, I'll just summarize what we argued is, when you look at the text, the term lake, river, and stream is not defined specifically in the code. And so the case law I cited tells us that it's appropriate then to go to other sources for the definition. We provided you the dictionary definition, which the case law does endorse, and the dictionary definition of a river is a large natural stream. And so a man-made canal clearly falls outside of that. And as other context, what we pointed out is that in a prior hearings officer decision here in Deschutes County, when the hearings officer was contemplating whether the 100-foot setback, which also applies to rivers, lakes, and streams, whether that applied to a man-made water feature, and the hearings officer agreed that it did not. So based on that argument, we believe you only have to get to, is this a boat slip or not, or is it a boat landing? And it's a boat landing. It's not a boat slip prohibited.
Mr. Kovac, could I interrupt you real quickly?
Yeah.
Could you give, just because there's a couple, three cases that hearings officer's decision, at least a couple in the record, could you confirm to me so I don't make a mistake and look at the wrong case? And I don't want to presuppose anything here.
The case number is LM-05-188. The applicant is Kenneth Kulfish. Oh man, I'm going to butcher it. Kulfish. And the discussion that I'm referring to specifically is on page 5 of that decision.
Okay, thank you. That helps. Just makes it more efficient when I look at it.
Right. So back to the modification. So we did this belt and suspenders alternative basis because staff raised the question of whether our argument was correct or not. And And like I said, we believe it is, but then we went through the verification of a non-conforming use, and I'm not going to get into the law on that too much. It's in our written letter that we submitted earlier this week. But the facts are pretty clear that we submitted photographs in the last session from 87 and 89 that clearly show this feature, this landing, where it is now. And then we've got evidence in the form of pictures from 2012, 2014, 2017 that are in the record that continue to show it in existence. Now, there is this presumption if it was there in 2012, you presume it's been in existence and lawfully established. But we went beyond that again. We went back to 89 and 87 and demonstrated that it was there. We've also demonstrated that it's been consistently there. Staff raised an issue of whether it was bigger now than then. We don't believe it is. I think the most important thing is to look at the 89 photograph. The 89 photograph is clearly from a very, very high vantage point, and you can see it's a fairly significant feature. The later photographs where it shows it perhaps a little smaller, they're closer up, and the other factor is there had been grass that had started to grow into it. So our position is the evidence is pretty compelling that when the Hansons cleared the grass out and some sediment, they really basically took it back to where it was in 1989 and not larger than it was. The use of it, Ron Hansen has demonstrated the best his ability. What they've used it for is what they believe everybody used it for, which is, personal watercraft where you have to get in and out, safely from the ground. And we believe the nature of the use has not changed one bit from the reason it was created. For the review on the fill and excavation, we did raise a question. We wondered whether or not that was required. If you agree with us that it's a replacement or restoration of a non-conforming use, and the reason we raised it is the people up the street in the decision from 2017, the Ganta decision, they restored a boat slip very similar. Only it looks like it was somewhat more extensive work. They put posts in the canal and they put boards up along the side, really made it into like a formal structure. And there was no conditional use for any fill or removal in that application. So we did raise the question of whether or not it would be required for a replacement or restoration. But notwithstanding that, you'll see in the burden of proof, and you'll see in our written material, we have gone through the process under 18-128 for conditional uses for fill and removal. Particularly, the subsection is 270, which applies specifically to fill and removal. So we did go through that analysis. And I'm not going to go through everything because on a lot of the criteria, particularly the general criteria for conditional uses in 128.015, there really doesn't seem to be a lot of dispute, even from staff and neighbors, about whether the site is appropriate for this use, whether transportation facilities have been impacted. None of that seems to be an issue. A couple of issues came up under 270. One was, I think, to describe the nature of the use so that you could establish, no practical alternative. And Mr. Hansen put in some supplemental written testimony on the 31st of December, explaining their use of it and why it's got to be there. Another issue staff raised was whether there was any impact on the hydrology. And what we've done on that is a couple things. One, we've got Karen Allen gave us a video from 2024, 2 years after the work was done, and an email explaining that from her perspective, she's the wetland biologist and environmental consultant that did the delineation, and she's saying from her perspective, nothing on the flow, nothing on the hydrology has been impacted from this work 2 years later. And then in the other case, it's a little bit relevant, I think, maybe more than a little bit, but we also have a memo from Beacon Engineering where they gave you some really good background on kind of how the river is controlled and how the flood flow is controlled. And I think that also helps support Ms. Allen's opinion that this modest scraping of the vegetation and sediment has had no impact on the hydrology of the canal or the Deschutes River. And then staff asked a question about whether or not we showed that the essential characteristic, quality, and density of the vegetation before and after were the same. And again, it's kind of hard after the fact to do that. But what we did was, again, we got Ms. Allen in and she took a look at everything. We've given you some photographs from 2024 to show what was there in 2024. Mr. Hansen's testimony, written testimony, is it's about the same as it was before, except for where they cleaned out the landing. And then Ms. Allen did a much more extensive evaluation of what she would plant. So one of the things we thought would be helpful as far as a conditional use permit is if the hearings officer agrees with us that we've met all the other criteria, a condition requiring some replanting in the area to even enhance that area better than it was before would be appropriate. And on December 31st, when she got back from her trip, Ms. Allen sent over to me, and I provided it to the record, a copy of a planting restoration plan, just out of an abundance of caution in case the hearings officer feels that some additional planting to enhance the area would be an appropriate condition. And my clients are more than willing to accept that condition of approval. So, on the boat landing, I think that was the only permit that staff indicated we needed. I couldn't find any reference to landscape management review for the landing, or any other review. To the extent landscape management review would be required, I would refer you back to the 2017 case down up the stream. And because there's no structures, staff agreed in that case, there really wasn't much to review. We are in the wildlife management area too, but I think staff commented that with no fences being proposed, there were no issues there either. So on this application, we think we've submitted evidence to show compliance with all of the relevant standards, and we've done a really specific job of trying to address as best somebody can after the fact the few questions and concerns that staff raised. So unless there's questions, we're going to rely on what we've got in the evidence and my rather detailed written letter that I submitted earlier this week.
Thank you, sir. And this is maybe an unnecessary question, but I want to make sure that I'm on the same page with your request, and that is, if in fact I find that the boat slip is on the canal, and the canal, therefore, it's not actually a boat slip. If I do that interpretation, then obviously findings are going to be required to demonstrate from my perspective in the decision on that. But if in fact I make that decision, would you still prefer that I make alternative findings on your modification?
I think that would be appropriate. Staff has raised the question or the issue that the excavation and fill CUP would still be necessary in a restoration. I think we've met those standards clearly, so I think alternative findings for the record would be appropriate.
Okay. And finally, I'll address your issue that you raised in your most recent letter regarding a final argument at the conclusion of the hearing. Okay. So the only person you can blame on not putting that in the order was me. I probably should have addressed that. I don't believe that I technically have to keep the record open at all after this particular hearing, but always trying to do whatever's necessary to get the most correct or best decision is always important to me. And if I find that's necessary, I believe I have the discretion to deal with open record issues as I feel necessary. So we'll talk about that later. Okay.
Okay. Yeah.
All right. Anything further, sir?
Not in our case in chief.
Okay. And is there any testimony in support of the application?
We're not presenting anymore.
Okay. So is there anyone else, either online or present, that would wish to testify in favor of the application?
Hearings officer, there are 2 attendees on Zoom. Neither of them are raising their hands. And then we have 3 people in the room. Would any of you like to testify?
And this is in support of the application.
Okay. No one in person and I'm not seeing any hands raised online.
Okay. This is certainly an opportunity now for anyone who's in opposition to present their testimony. So, Ms. Stewart, I'll let you do the logistics on that one.
One hand was raised. Is the name on Zoom is Renee.
When you're ready, if you could identify yourself for the record and give us your mailing address. And please spell your first name and last name, because I can spell Renee a couple different ways, and I'd like to spell it correctly.
Sure. So my name is Renee, Renee, and my last name is Eid, E-I-D.
You testified last time. Okay.
Yes.
So I should have known. I should have known better.
That's okay. So just listening to the testimony earlier, I think there's still the issue of what, and I'm obviously not a hydrologist or an environmentalist, but there's still the issue of what I would refer to as a sill wall, or a wall that protected the opening of the canal, that seems to be kind of have been brushed under the rug here. In the testimony at the last open hearing, the owner said that he had shortened that wall, removed some mature trees from it, which looked unhealthy. They were lodgepole pines. Of course, they're not going to be the most robust examples. They're growing in a waterway. And my concern is the health of the canal and flood issues that would impact the whole neighborhood. And I feel like that hasn't been addressed. And the little bit of the hydrology work in this report and what has been submitted is very thin, as well as the erosion analysis. And I appreciate that our neighbors are, looking at replanting and doing the right thing, and that this is a property they love and use. But I still have concern for the health of the canal. Also, in the last testimony, or the last hearing, there was talk about this having been an oxbow that had been restored. And I think it's important to know that the other part of the oxbow, what I would call the upriver portion, has filled in with sediment. But where my property is, and the property that we're discussing today, is on the other end of it, the downriver side, which has remained healthy and open and has water in it for a good time of the year. My concern with that wall being shortened, and now this, what we're calling, I think, minor sediment removal, is going to add to the sedimentation of this end of the canal, and we're going to find ourselves in the same position as our neighbors upriver. And I just don't think that has really been addressed in any of what I've seen submitted online. And what I have seen, what I have seen was just, I think, one video at one point in the year, and this is a pretty dynamic waterway between the thawing and the and the icing over, and then as well as the fluctuation in the Deschutes River by way of the Wikiup Reservoir and releases. So
thank you. And kind of like I asked Mr. Kobach for some help making sure that I was absolutely clear on what case I was supposed to be looking at, and my question to him. And this may be unfair to you, but with your issue regarding the sediment and the impacts on the river or the canal, do you have a specific or number of specific approval criteria or rules, laws that I should be looking at in the context of your testimony? And like I say, it may be an unfair question.
Yeah, I'm not an attorney, so I can provide to Audrey what I can research and find and add to what I submitted last time.
Okay, I have made excuse me.
But thank you for asking.
I have made a note of just what your response was. As I indicated, Mr. Kobach, just shortly ago, I have certainly at least a possible issue with respect to keeping the record. Oh, excuse me, I swallowed something wrong. Keeping the record open. I believe that I technically don't have to keep the record open beyond the hearing today, as it's not an initial hearing, and that's when state law says I have to keep it open for a certain period of time. But I will consider that, and I'm going to also rephrase what you just said. I can provide, and putting words in your mouth, say you'd like to have an opportunity to provide additional information regarding my question on relevant approval criteria. So
Yeah.
anything else?
Yeah, I apologize if I misunderstood, but I thought by way of it being refiled as a non-conforming use, that opened it back up to comment again. So that's why I attended today.
It did technically until this hearing,
Okay.
but I said I'm keeping an open mind both to Mr. Kobach's request he made a request to have an opportunity for a final argument, and I'm asking, and when you said you could provide, I rephrased it. And so I'm keeping an open mind on the open record issue, but
Thank you.
I'll make that decision at the end of this particular hearing today.
Okay, thank you.
Thank you. Anyone else wishing to testify in opposition?
We have one other attendee online. They are not raising their hand at the moment.
All right, I will consider the last person testifying as being the sole person today that has testified in opposition. Is there anyone here who wishes to testify as a neutral person? I'm as long as I've been doing hearings for the Deschutes County, I've yet to figure out what that means. But if there's anybody else who wishes to testify, I just want you to say it now or forever hold your peace, kind of thing.
No one online or in person is raising their hand.
Okay. Mr. Kobach?
Thank you, Mr. Hearings Officer. Just briefly in rebuttal, I never dismiss concerns. They're almost always valid. But I just want to remind the hearings officer that the standard is substantial evidence. Ms. Allen is a consultant and expert, and she has the only evidence that there is no erosion. And I think that evidence trumps a general concern unsupported by any evidence, no video, no photographs, nothing. And I would also encourage you again, and I think you can do this, to review in this case the record from the companion case and read the Beacon memo, which also I think addresses general hydrology and other issues related to the flow of the water in this area. So that's all I wanted to say.
Okay. Ms. Stewart.
Thank you, hearings officer. Staff is supportive of an open record period. There were two letters, or one letter for each of these applications submitted yesterday that provides some more detailed arguments, and just to the extent they could impact how we look at other properties or other applications and making sure it's sort of consistent with past interpretations. A chance to respond to those in writing would be helpful. And then it wasn't raised in the applicant's modification, but I do want to flag for the hearings officer that a couple definitions from 1804-030 were updated between the date that the original application was submitted and the modification was submitted. The applicant didn't make a new sort of goalpost argument regarding which are applicable. So in my materials, I've just been moving forward with the original definitions that were used. But to the extent the hearings officer has a different opinion on that, that's something we'd also like to respond to in writing.
Good. Mr. Kobach, I'd like a response on that.
Well, on the goalpost rule, I didn't think it was necessary because in my experience, a modification has never invoked new code provisions because you're modifying the original application. It is not considered a new application. I admit, I don't know that I've had this specific question come up in Deschutes County. I have had it come up in the city of Bend and other jurisdictions, and based on my experience, a modification of the application is not a new application. Otherwise, it would be called that, a new application. And I think maybe you and I dealt with that in City of Bend. I can't remember exactly if you were the hearings officer, but I know this has come up. And so that's my position on that specific issue. If you want me to comment more on open record, I'm happy to do that.
Yes. Yes, please.
Okay, so a little bit of this is on me, and then I think scheduling with staff and myself and not being able to communicate. When I started writing this letter, my plan was to write a shorter letter in each case and reserve the right to do final argument. And then staff and I exchanged some emails. We're going to talk, and I'm trying to talk about logistics and what the hearing was going to be like, and that was going to be one of my issues. And we never got to talk. Nobody's fault. It's just we're busy people. And so I put everything in these letters. That is my written final argument. In each case, you have it. So based on how things kind of transpired, I came in here today and I forgot to change the letter. That's really what it is. I forgot to edit that first part where I reserved that right. We no longer need a final written argument. We don't anticipate putting in new evidence. So from the applicant's standpoint, an open record period is more time and more expense, and it's been expensive already for my client. So we would prefer not to have one. But I understand you have the discretion to grant one anyway.
Assuming I exercised my discretion to grant an open record period, can you make a suggestion as to, even if it's not your preference, what that might look like from your perspective? And you can certainly discuss this with your client if you'd like.
Well, I would need, my clients are going out of the country soon, and I've got a commitment the 25th through the end of the beginning of March. So I wouldn't want to have something due when I'm gone or when I can't communicate with my client. So
what would the open record period look like for you?
What would it look, can I ask staff, what would it look like now if we did the 7?
Yeah. If we did a standard 777, the initial evidence would end on February 12th. The rebuttal period would end on the 19th, and then the applicant's final argument would be due by the 26th. That 7-day for the applicant's final legal argument, they can choose to waive that if they email me and say that they've submitted everything that they would like to. And the applicant is huddling up with his clients.
That will work for us for written stuff.
Okay. Anything further, Mr. Kovac?
No, thank you, sir.
Anything further, Ms. Stewart?
If we're done with deciding the open record period, I do have some notes on just how to submit those materials.
Okay, let me give my editorial comment on the open record, which one of the experiences I've had with Deschutes County is that, and one of the infatuations that I had when I first came to Deschutes County was the preparation of staff reports and the predilection to not get too opinionated on things and rely heavily on the hearings officer. And from a historical perspective, I've spent 18 years at the city of Portland, and the planners had opinions on everything and not afraid to express those and not afraid to be very upset if I didn't agree with them. So one of the infatuations I had with Deschutes County was that I was given a whole lot more discretion to do things without being pressured or pushed from the staff's perspective. But there is a cost to that because staff has significantly more time and effort put into these cases than I will ever have. And they also have probably more expertise, well, significantly more expertise would probably be more accurate, with multiple cases and trying to be consistent with the interpretation of their code provisions. And with that in mind, when I get an issue, as Ms. Stewart has raised, which I appreciate. I appreciate all issues. I appreciate getting to make decisions on all kinds of things. But it would be helpful if in fact, during the open record period, if in fact the staff has issues regarding or opinions or positions regarding the goalpost rule, has opinions to some of the other issues that were raised by the definitions in the original definitions versus new definitions versus whatever. Those kind of things are always appreciated by a hearings officer, because what we're given is so different than what poor Ms. Kobach is given, and because his client walks in and says, make it work, and the planning staff is basically has each other to have the ability to throw ideas off of, and supervisors or people who've been there a long time give indications, oh my gosh, that's not going to work. You got to consider this in the context of what we've done in the past. I don't have those issues. I have an issue is what is in the record I'm stuck with. And the lack of any clarification as to what is appropriate in my decision. Your input, both staffs and applicants and the opposition, is always appreciated. So I can't tell you, and have never been able to tell anybody, what evidence they have to put in or what argument they have to put in, but I'm just making a request for both staff and applicant and any opposition, as I did with Ms. Eid, if I mispronounced it, is I want to know what the relevant approval criteria is from her perspective, and then I can answer it because that's in the record. But if you expect me to guess, or you expect me to be really smart and be able to figure all this stuff out without your help, then I think you're making a mistake. And so all I'm asking is, in the open record period, you all have, each one of you, whether you're staff, whether you're applicant or you're opposition, you each have your own expertise. Use it and share it. All right. So I'm going to agree with you, Ms. Stewart, on your proposed 777, which is listed on in my copy of the opening comments. That would be February 12th, February 19th, February 26th. I'm going to have you now give instructions as to how the information is placed in the record.
Thank you, hearings officer. I will share my screen again. For the open record period, please keep in mind all submittals should be addressed to me. For email submittals, use audrey.stewart@deschutes.org. The county does not retrieve information from a website link or personal cloud storage. It's your responsibility to submit all evidence and testimony you want the hearings officer to consider. Any electronic submittals must be received by the county server by 4 p.m. Please do not wait until the last minute to submit your evidence and testimony. New evidence and testimony can be submitted until 4 p.m. on Thursday, February 12th. Rebuttal testimony can be submitted up until 4 p.m. on Thursday, February 19th. And the applicant has until 4 p.m. on Thursday, February 26th to submit their final legal argument. And with that, I'll turn it back over to the hearings officer.
Okay, I have nothing further other than to reiterate the dates, and I just want to make sure it's clear that by 4 p.m. on the 12th of this year, February 12th of this year at 4 p.m., you can submit new evidence. You may submit responsive evidence, only rebuttal evidence by 4 p.m. on the 19th, and only the applicant has the right to submit a final argument, and that is 4 p.m. on February 26th at 4 p.m. Any questions, Ms. Stewart?
No questions.
Any questions, Mr. Kovac?
No, sir.
All right, thank you. At this point in time, the oral portion of the hearing is closed. I await your written submissions and will review each and every one of them. So we will close this hearing at this time. Just, Ms. Stewart, a quick question. Do I just stay on for the next hearing? Or do
Correct.
we
And
have
for,
to log back in?
Correct, hearings officer. And just for anyone else who's watching, it's the same Zoom link. So you don't have to log out and log back in. We'll just move straight into that second hearing.
All right. Ms. Stewart, you're ready to do that?
Yes.
All right. Then we will go on the record now for cases 247-25-00306-CU, 247-25-0000307-LM, and 247-25-0000308V, and finally 247-25-00767MA. The time is about 2:14 on February 5th, 2026. As I have indicated, for those of you who are still on, but I'm doing it for the record of this case, my name is Greg Frank, and I'm a hearings officer in this matter. Before we turn to the particulars hearing, I'm going to turn things over to Ms. Stewart, and she's going to describe, once again, how the electronic process works. Ms. Stewart.
Thank you. For the record, my name's Audrey Stewart. Again, I'm an associate planner with Deschutes County Planning Division. The item before the hearings officer is a conditional use permit for a dock, landscape management review for accessory structures, a setback variance for play structures, and a modification of application. Today's hearing will proceed as follows. First, staff will explain the hearing format, followed by a brief presentation. The county has established the following time limits: 30 minutes for the applicant, 10 minutes for agencies, 3 minutes for the general public, and 10 minutes for the applicant's rebuttal. However, the hearings officer may modify or eliminate these time limits. Once again, when the testimony portion of the hearing begins, the applicant will present first, followed by any agencies, next those in support, then those in opposition, and finally anyone neutral to the applicant's proposal. The applicant will then have a chance to make rebuttal testimony, and finally, staff can make closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please again provide your first name and last name, as well as your mailing address. If anyone in person would wish to testify, please add your name to the sign-in sheet. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When hearings officer Frank asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, or if you've called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you're in person, please submit your written testimony to me after your oral testimony. If you're participating remotely, you can submit your written testimony via email to audrey.stewart@deschutes.org. Hearings officers Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Any written or oral testimony that was previously submitted is still in the public record and does not need to be resubmitted. Anyone is able to provide testimony at today's hearing, and comments that were provided at the December 4th hearing do not need to be repeated. Are there any objections to the format of the hearing? If you are attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn it over to hearings officer Frank.
Thank you, Ms. Stewart. As Ms. Stewart described, we are following the normal hearing procedures in the county code, and I will provide sufficient opportunity for everyone to participate at an appropriate time. I ask your patience as we make sure we get through each of the steps Ms. Stewart just outlined. The application is being considered through a quasi-judicial process. I will consider only the factual evidence that's in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report. The public notice and staff report are posted on the county website, and they're also available from staff upon request. It is important that you direct all your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address that criteria or criterion. And I urge you to explain why the criterion must apply and to do so with specificity so that other participants may respond and so that I can actually address those issues or that issue in my decision. The failure to raise an issue with enough detail to enable me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval with enough detail to allow me to respond to the issue in my decision precludes an action for damages in circuit court. As just noted, I serve as a county hearings officer, and I do so in this matter. In that role, my job is to be a neutral observer and decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial. I do not represent the county's interests or the interests of any participant. To that end, I will state for the record that I do not have any relationship with the applicant, and I'm not aware of any connections that I may have with other participants in this proceeding that would prevent me from remaining impartial. I have communicated with staff, but only discussed the logistical procedures of today's hearing and not the substance of that application or those applications. I do not have any ex parte contacts to disclose. It is my obligation to preside over the hearing in an efficient manner. And then what I'd like to find out here, and I didn't do this in the first hearing, but I'm anticipating we don't have a whole lot more or less, is who do we have here? Do we have people on the applicant side? Do we have people on the opposition side? Can we tell who's around?
Thank you, hearings officer. It looks like the two members of the public have dropped off the Zoom hearing. So at least for the Zoom portion, it's just staff and the hearings officer. And then for folks in the room, I believe they are all with the applicant's team.
Okay, thank you. Before we begin, does anyone that is still with us wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter?
No one in person is raising their hand.
All right. With that, Ms. Stewart, you indicated you had a presentation. This is a time and place for that presentation.
Thank you, hearings officer. Similar to the previous hearing, today's hearing is a continuation of a public hearing that was held on December 4th. Following that hearing, the written record was left open, and on December 31st, the applicant submitted additional materials, including a modification of application. In response to that submittal, the hearings officer issued an order on January 13th to reopen the written record and continue the public hearing. The modification of application also restarted the 150-day land use clock for this application. The new date by which the county must issue a final decision is June 1st, 2026. Any comments and materials that were submitted at the previous hearing will continue to be in the record and do not need to be resubmitted. The subject application involves a conditional use permit for a community dock, landscape management review for accessory structures, and a variance to the 100-foot river setback for existing play structures. The applicant's modification of application provides an alternate pathway to have the dock reviewed as a non-conforming use. In the original staff report, the dock was reviewed against the provisions of 1896 of Deschutes County Code as new development. Since the December 4th hearing, the applicant has also submitted materials related to the landscape management review and setback variance applications. Yesterday, the applicant provided a letter and supporting materials, and these have been uploaded to the record. Staff notes this letter was submitted after a staff memo was issued on January 28th, so that memo does not respond to any new materials. The full record is available at the link shown here. And with that, I'm available for any questions from the hearings officer.
I have no questions at this time. I appreciate the presentation. The applicant or applicant's representative, this is your time to make your presentation.
Thank you, Hearings Officer Frank. Again, Chris Kobach, 937 Northwest Newport Avenue, Bend 97703. I'm here to present on behalf of the applicant, the Hanson Living Trust. It's going to be a little bit of the same general theme. I'm going to start with the modification and then go summarize some of the other issues. This one's going to be a little longer because there's a little more involved. The modification request is for a slightly different reason. As Ms. Stewart announced, and I think was probably obvious from the last hearing, the application was based upon the knowledge that the client, my client, the owner, had at the time. I didn't prepare the application, but an experienced land use consultant did, and they did the best they could with the information they had, which was when the Hansons bought the property in about 2018, there was a dock, like almost every property along the river and the canal. And naturally, they assumed the dock was fine. Somehow later, the county determined that their dock that was there had not been approved. They provided information that there had been work on the dock in 2012. We all knew very little beyond that. And not having any history with the property, the Hansons had no reason to believe anything but what staff had said. And so they applied for a new community dock under 18.96 floodplain management. And then there's some other related reviews, the landscape management and wetland fill. And the modification here is because as the hearing progressed and the investigation continued, we found the gentleman who did the work in 2012, Dustin Dowell. And he gave a written statement that's in the record that when he came on to do the work in 2012, there was an existing dock in the same location, about the same size. It was old, it was wooden, it was in need of repair or restoration rather, not much use for it. And so what he did is he replaced it. Generally same location, same size. He may have reconfigured a little bit because some trees had grown in, but and most importantly, you know, he's a construction expert. You know, it's what he does for a living, and he sees a lot of wood. And he said, based upon his observations of the condition of the wood of the original dock, it was more than 20 years old. So with that, we felt we should modify to verify a non-conforming use based on, you know, ORS 215.130 and the county code 18.120, which has this presumption. And the presumption is that if you establish that something was there for 10 years, its use, it's presumed that it was lawfully established and continued uninterrupted to the date of the application. And so based on Mr. Dowell's testimony from 2012 and the application date more than 10 years later, we have the presumption under the county code and state law that it was lawfully established and that it was it continued uninterrupted for till the application date. Staff has a very circumscribed ability to rebut that. They have to show that that it was unlawful at the time it became non-conforming, or that the use prior to the 10 years was different in nature or different in extent. So what staff has presented to you in the memo is some very blurry aerial photographs taken from a very high distance. And I don't think it's sufficient to rebut the presumption. If you could look at later photographs, even from 2012, 2014, depending on the height of the plane, depending on the angle of the photograph, depending on the time of the year, the whole landscape there looks different. Even pictures of this same dock look very different. It's near some trees, and so in some photographs, it's shrouded by trees, the current one. In some, it's more prominent. We don't believe those blurry photographs from 80s and early 90s are sufficient to rebut the presumption that the dock was there before 1989 and lawfully established. But we went a step further. We kept digging, and we found a gentleman, John Ash, retired Deschutes County lawyer, who's here today just to observe because he's very interested in this. He's been going to that area since 1984 and explains this story in a written statement. And he remembers a dock on that property back in the mid 80s. And before even houses were there. And his history there is kind of significant in that, you know, the canal was built, and you can see from the 89 and 87 photographs, the canal was built with these other features like these landings, well before anybody put houses up. These were really like campsites for a long time. And people, as Mr. Ash explains, would use them. They'd haul up trailers or bring tents and they'd camp there. And they had their docks and they had their summer vacation places before they had houses. And in fact, there's still an owner in the neighborhood that Mr. Ash knows that still uses their lot that way. They have a dock and they don't have a house. And so he remembers that dock. And then he also then has a long-standing history. He moved on the property or up the street or up downstream, I guess, in 2002. He remembers the dock then, and he remembers an old dock ever since. We asked him to go back, look at all of his photographs in history to see if he has anything. And he has one photograph which he did not intend to take of the dock, and we don't represent that he did. But it does show on the far left corner of that photograph the feature that he remembers seeing as a dock back in the mid 80s. And so to the extent there's any value in these fuzzy photographs from staff, Mr. Ash clearly refutes that with direct personal knowledge that there was a dock on that property before 1989. His testimony proves that it was there consistently since then. And we're not aware of any evidence to suggest Mr. Dowell was wrong when he says the dock that was there when he got there was the original dock, and it was more or less the exact same size. We know he said it's in the same location. He did some reconfiguration, but his best recollection is he just replaced what was there. And so that's our application on the non-conforming use / structure. But let's go to the conditional use. So because we applied not knowing this information, the conditional use for a new dock was applied for. It is an alternative basis. And I want to talk about just a couple issues there. One of the issues is the size limitation. That's kind of the big difference, right, between going back to a non-conforming use. Really, I think the only thing that matters, because I think we've addressed everything that we need to get a new dock approved as a conditional use, it's really just a size thing. The dock's about 500 square feet now, the replacement. A new community dock can be 320 square feet. And there is something in the record that shows you that you can rely on if you get there, that it can be reduced if necessary to 320 feet. The other issue staff raised on the dock size was that because the trust owns both properties that use the dock, they don't believe that it qualifies as a community dock. Again, I think that's a little form over substance, but it can be handled easily with a condition. Oregon recognizes the separateness of the legal separateness of entities. If necessary, the Hansons can put the other property into a separate entity, and they can address staff's technical concern over how the 320-foot limitation applies. And there's plenty of case law that if a property is owned by the person and a legal entity, they're separate. It comes up in condemnation. It comes up in a lot of contexts, but that is the law in Oregon. So we can address that. So the next thing I want to talk about is the conditional use for fill. Again, I raised the question about whether you have to do that for a replacement. it was just unclear to me from the code whether that was required. And it was really unclear because of prior treatment by the staff of a similar situation up the canal where somebody replaced something and they didn't have to go through a conditional use, even though it was in an area of mapped wetlands. Staff's position now seems to be, you still got to do it. And if we do, that's fine. We'll again ask for alternative findings because we addressed it anyway. We addressed it in the original application. We addressed it with some supplemental evidence on December 31st. We've addressed all that, and I'm going to go through it because there aren't very many issues there either. Again, under the conditional use for, if it's a conditional use dock, if it's required to go through that, we've ticked off all of the basics in 128.015. The site design and operating characteristics of the use, we've addressed that. Adequacy of transportation, the natural physical features of the site, including but not limited to general topography. I think staff raised one question about hydrology or erosion under that section and the flow of the river. Again, what we did was the best we could. We had Karen Allen, who's a consultant in environmental issues, looked at the river in 2024, and she could see no impact on erosion. She could see no impact on hydrology in the area. I know she was focused more on the landing, but the same, I mean, she was looking at the whole river. You can see from the video, she's going through the river, down the canal. Her opinion was that the hydrology hasn't been changed. None of the natural features have been changed. And then again, the Beacon memo explains really a lot of good things. One is the history of the river and how it's controlled and how there's never been a 100-year flood. These features that are close to the 100-year flood, they're never going to be impacted by the river because the irrigation district controls it so much. And they found no impact or any issues with hydrology or natural features of the river. So we've given you that evidence on that. And then we went to the 270, 128, 270 features. And there were a couple issues that came up in the staff report. The first one was whether or not, there's one, it's all under D. D is the section, the critical section there, subsection D. Whether there was a practical alternative. That was one under it's subsection 270D2B. And to address that, Mr. Hansen gave his supplemental written testimony explaining why for this particular use of dock, there is no practical alternative to what they did, replacing this dock. It's where you have to step in and out of a boat. It has to be kind of designed that way for safety. And I think he explained as well as anybody could why that's the only place no other location would have any less impact on the ground. For example, if you took this dock off and moved it, there's nowhere to move it where a dock where you're not going to impact the area immediately around the river because a dock by its nature has to be on the river. So I think he addressed that. Staff raised a question under 2E, the essential character, quality, density of the vegetation. This one was a little more challenging. Mr. Hansen did the best he could with the history of the site. This is an area where, on his observations, there's never been a significant amount of vegetation. And you'll see from the very, very old photographs in the 80s, there was always an access kind of path, the roadway going down to this area. Originally, and this is anecdotal, but I think there's a lot of facts that support it when you look at how the canal was built and where the bentonite was deposited when it was done. It looks like that's a source of access for the original work to construct the canal in the early 80s. And it shows up in almost every photograph, even the current ones. There's still this access path down to the water in this area. And so because of that, there's never been a significant amount of vegetation. Mr. Hansen's best recollection is based on his experience there. Vegetation is about the same as it always has been, looking back at whatever he can, old photographs. We did the best we could, and to supplement that as well, Karen Allen has established that if you believe additional plantings are required in that area, for the restoration of the dock, it's more than feasible to impose a condition requiring that. She's given a plan for the other side, and I don't think that plan covers everything by the dock, but she could easily do that as a condition subject to staff's approval. I don't think staff would have any questions about her her qualities and her qualifications. So we would propose that. Another issue with the dock that came up was whether it was susceptible to hydrodynamic forces. And that's also under one of these conditional use. I think it's B1D. And what we did there is, again, we got the, and there's these horizontal members on the dock that you can see. And staff agreed that the dock was constructed more or less to allow water to flow through, but they had a question about whether that horizontal member being at or below the floodplain would have any effect on the flow of the river, or whether the river would have any effect on the dock. And then we had a professional engineer, or Kaufman from Beacon, go out to the site and evaluate it. And you have his technical memorandum in the record. I mean, they've established a couple things. One is there's really 5 piers that are within this floodplain, or three or five. Yeah, maybe 5 down below along the river, and they're, small cylinders like a foot. And that's the only excavation and fill that took place by the river. All the other work was upland. There's other piers and footing upland, but that's not near the river at all. It's outside the wetland. So that doesn't, the only fill and excavation that we believe would be in that little skinny wetland that's shown on the delineation is these, it's either 3 or 5 little piers where dirt was dug out, piers were poured, so there would be a little excess dirt. And I contrast that with the application where none of this was required, where they put in 7 4x4 posts in the canal, where there's mapped wetlands. None of this was required. So we believe that evidence really establishes that even though we feel we're being held to a slightly different standard, we've met that standard. There has been no significant impact on anything around there, no erosion. And again, any plantings that are necessary can be supplemented with a restoration plan, which we would agree to a condition to impose that. So we think that's really the dock issues that we see. We didn't see staff explain anything about how whether landscape management was required for the dock in the staff report. If it's there, I just didn't read it. So we don't believe landscape management is required. It's a conditional use in that zone. But if it is, it's natural wood. It blends in. You can see the pictures of it. It's and nobody's complained. No, you heard the neighbors who are opposed to extent on the boat landing. They have no problem with the dock. It doesn't offend them. Nobody's raised any issues with the dock. It's natural colors, and the goal of the landscape management, as it's been explained to me by the planning director here, Mr. Groves, is it's to get compatibility. And we believe we've achieved that. So to the extent that review is required, and I don't read that it is, we've handled it. So on the next big stuff, it's the play equipment and some natural stone terracing and some at-grade paths. There's first a very big foundational issue, and that is, how does this river setback apply? And I'm not going to go into a lot of detail here because it's probably 3-4 pages of my written material with case law, text, context, a lot of detailed analysis that would take a long time to go through. And I know that you're going to read it very carefully, as you always do. So I'm going to just touch on a couple things, which is, we believe, and what we've presented is the specific setback when you apply the text and the context and the rule of statutory equity, where you strive to avoid an entirely unreasonable result, compels the conclusion that the river setback was not intended to apply to these types of features. It was intended to apply to buildings, dwellings primarily, garages, carports, things that would be affected by floodwater, things where people would be present, and things that would be much more intrusive when you compare it to the purpose for which that setback exists. And so if you conclude that the play equipment does not, and this minor landscaping does not have to, that it qualifies as being there without, notwithstanding the setback, well, then the only thing you have to look at is landscape management. And we've addressed that as best we could. If you look at the play equipment, it's compatible. It blends in, it's brown, natural wood, it's in the trees. And again, I think the best evidence of how compatible it is, even the people who are opposing the application next door have no problems with it. That's what they testified. I think they're kind of going to that rule of statutory equity, kind of unreasonable to conclude that innocuous children's play equipment should not be allowed on the property. And that brings me to one other foundational issue on the play equipment, and that is staff raised an interesting issue. It's another technical application of the definition of accessory use. And they say that an accessory use can only be on land if there's a primary use. And there isn't a primary use on this. The Hansons own 2 pieces of property next door. Their house is on one, and their children's play equipment is right across the line on their other property. And the question staff raises would be, you can't, as a family, you can't put play equipment on a parcel of property that you own next to your other property because of an artificial line, even though it's incorporated into your homestead, because you don't have another dwelling on that other property. You don't have another primary use. My position on that is, under the Johnson versus Star Machinery case, that is an interpretation that just cannot stand. It is utterly unreasonable and inappropriate. So I think you have to conclude that the play equipment can be on that lot, regardless of whether there's another use on it. And so those are the 2 foundational kind of legal issues. As to the landscape management, I think I've touched on that. The play equipment, it's pretty innocuous stuff. It looks really good. Nobody's raised an issue. The natural stones and the paths, there's even a question of whether they, the pathways, staff has, I think, mentioned that down the street, there's natural or artificial landscaping in the setback, but it's at grade, so it's not a problem. It's kind of the same thing with our paths. They're at grade. They're not really a structure, even if their definition applies. So we think that should be the rule on that one. I think I got to talk a little bit in the alternative about a variance. And I have a case here. I submitted this case that has been thrown around a little bit, and it's the 247-20-00201V case.
Say that again, please.
It's 247-20-00201-V. So this is
last 2 numbers. I'm sorry, it got distorted coming to me. It goes 00201, and the last 2 numbers
-V.
-V. Thank you.
Yeah, as in variance. Okay, so this is a fairly recent variance decision that the planning staff issued, and it involved a structure within the setback. And after the fact, the owners came in for a permit. And if you let's just walk through the standard for a variance. It's in 18.132020. And the first one is, the literal application of the ordinance would create a practical difficulties resulting in greater private expense than public benefit. Staff's discussion is simply that the literal application would require that the subject building be relocated, and it would result in substantial expense, $68,000, and no public benefit. That was it. Box is checked. Let's go to our position here. The literal application would require removing significant rock structures, these innocuous retaining terracing that are necessary to level the ground for walking, children's play equipment that's in the ground. I mean, a lot of it is, in cement. it would cost a fair bit. We don't have an exact number on it, but Mr. Hansen, based on the cost of an excavator, just to remove the rocks alone, at least $100,000 to get equipment in there and take all that out. What would be the public benefit of that? None. Nobody's complaining about it. It hasn't caused any problems. Most of it's at grade, except for the children's play equipment. That's far from the river. It is in the setback if it applies, but it's far from the river. So if you apply this standard as it's been applied in the past, I think clearly the Hansens meet it. And the second one is that the condition creating the difficulty is not general throughout the surrounding area, but unique to the applicant's site. In that case, staff said the subject building and development history are unique to the subject property. We can check that box too. The subject building and development, all of this stuff that my client put in, thinking it was fine, because it's not a structure in their view, is unique to the property. The fact that they'd have to remove it at significant expense for no benefit, that's unique to the property. So we check that box. The third one is that the condition was not created by the applicant. And it goes on, a self-created difficulty will be found when the applicant knew or should have known of the restriction at the time that the site was purchased. Well, there, the setback was in the code. A contractor apparently made a mistake. The applicant didn't catch it. They thought that this county would catch it. They were like, well, the county should have figured it out. County explained, well, that's not our job, it's your job. But nonetheless, they found that the owners relied in good faith on that belief. Now here, Mr. Hansen knew there was a setback of some sort. He testified to that in the first hearing. But to conclude that play equipment and rocks at the ground and pathways would be determined some offensive structure that couldn't be in the setback based on everything he's seen in that neighborhood, stuff that hasn't come before you because it hasn't been reported. He had no reason to believe that putting play equipment there would be something that wouldn't be allowed. Putting a path down to the dock wouldn't be allowed. That's an honest and innocent mistake that I think a lot of people would make and a lot of people have made. Not all of them have come to this level yet because it's all complaint driven, but a lot of people, I'm assured, based on my view of aerial photographs of this area and other areas, most of the people that live out there have had the same belief. And so I think Mr. Hansen and Joni Hansen can check that box. The last one is that the variance conforms to the comprehensive plan and intent of the ordinance being varied. Again, this one is hardly ever debated based on my review of the cases, but here the staff concluded that because the building is a pole barn, it's rural development, its isolated request for a variance does not detract from the rural characteristics, which is the intent of the setback provision. So if you look at this stuff, the purpose of the setback for the river is light, air, pollution, visual beauty, all good stuff. How does the alleged offensive development impact negatively that purpose? How does at-grade minor landscaping and terracing affect air, light, pollution? It doesn't, has no impact. Play equipment, the same thing. It's far removed. It's behind the trees. It has absolutely no impact whatsoever on the river, light and air. It doesn't have any visual distraction. If it was visually offensive, somebody would have complained about it. And you heard the only testimony you have from the neighbors is it's fine. We like it. And then I think I'd point out something that we pointed out before is an interesting thing, and also it goes to the third criteria about what you reasonably believe can be in the setback. Person like the Hansens, they could go out to Walmart or Costco or one of these stores. They could buy the most ugly, offensively colored plastic play equipment of any size, really, as long as it's movable, and they could put it in that setback under staff's view. And there's nothing anybody could say. And yet here, this very tasteful stuff somehow would be inconsistent with the purpose of the setback. That doesn't really follow. So I think on the fourth criteria, that the variance conform to the comprehensive plan and the intent of the ordinance being varied, I think that you can find that the Hansens meet that criteria as well. So we hope you don't get to the variance. I know they're always a little bit challenging for everybody to deal with. They're usually not good situations where people do get in a bind because they either buy something with a problem or they misunderstand the law. But they exist for a reason. And if you meet the criteria, and clearly based on this decision, I think we meet the criteria, they can be granted. But again, you only have to get there if you disagree with my legal analysis on what can and cannot be within that specific stream setback. And so that interpretation, I think, is very important. And if you get to where I think you need to get to on that, where I've argued you have to go, you don't even have to get to the variance. So that's, unless you have questions on this one, I think that's what I have for the case in chief.
No questions at this time, Mr. Kovac. Did I get the impression that you had additional testimony on something else?
No.
Okay,
No,
I did.
no, unless there's, I don't know if anybody's going to testify allowing me to rebut or not. So I'm just leaving.
Okay. Anyone else wish to testify in favor or support of the application?
We have no one over Zoom or in person.
Okay. Anyone wishing to testify in opposition to the application?
No one's here to testify for that.
Okay. There's nothing to rebut then, Mr. Kovac. Since there's nothing entered either in opposition or does anybody wish to testify neutral? I always forget to ask that only because I don't even know what it means.
No one here, hearings officer.
All right, thank you, sir, ma'am. All right, Mr. Kovac, nothing to rebut. Anything, Miss Stewart, that you'd like to add?
No, actually, my only comment, just because the question was raised about landscape management review, I would direct the hearings officer to 1884050A, which specifies that new structures that require a building permit must go through site plan review against the provisions of landscape management combining zone. And so in my original staff report, I was under the assumption that only that small sort of cabin accessory structure would require building permits. And so only that was addressed for landscape management. And we historically have not required it for docks and other structures that don't require building permits.
Anything else, ma'am?
No
All
other
right.
comment. Thank you.
Okay, thank you. Mr. Kovac?
No. I would like to explain one other thing, though. This letter has the same little flaw as my first one. Is when I started writing it, I wasn't sure what the procedure would be, but as you can see from the 18 pages, I've given you the arguments and everything. So this will be our final written argument as well. We're not going to ask to have additional time.
I've heard no request either from staff, the applicant's representative, or any other person requesting an open record period. Is that correct?
Staff supports one mostly to keep the two applications on parallel timeframes, and also just in case there is anything in that letter from yesterday.
Mr. Kovac?
Well, again,
Any objections to the open record period, keeping them consistent? And I'm looking at it. I hadn't thought about that comment until Ms. Stewart just made it, but there are a number of not overlapping issues so much as overlapping factual aspects, evidentiary aspects that would be helpful from my drafting perspective to make sure that I'm drafting both decisions at the same time.
I appreciate that. I think that could be handled without an open record period, which would be that we would just agree that your time for the decisions are the same. And I think that's an easier way to deal with it. But I understand if you get a request by anybody for an open record period, you have to make that decision. You have that discretion. We don't feel it's necessary, but that's our position.
Ms. Stewart, comment?
Staff does support an open record period, just if not necessarily saying that I will submit a new memo, but just leaving that possibility open in response to anything raised at today's hearing or in recent materials.
All right. Just for information, Mr. Kovac, under my contract, I'm required to issue my decisions within 21 days, the date the record closes. I'm not sure how I modify that contract in a hearing context. It doesn't mean it can't be done. I understand that, but I think just for a matter of consistency, we'll keep the record open based on the hearing today. This one doesn't seem to be nearly as controversial, at least from opposition perspective as the earlier hearing. But I make presumptions at my own risk. So I think what I'm going to do is keep the record open. Mr. Stewart, you want to give us the particulars of the open record period?
And to confirm, would this be the 777 that we're using for the other application?
Yes, and that's based on your comment that consistency as far as when the record closes is desirable. I'd never say I don't want information submitted into the record during the open record period. That would be inappropriate. But it doesn't appear that this particular hearing is going to generate significant issues during the open record period, other than perhaps staff's contribution.
Thank you, hearings officer. If we're following a 777, the period for new evidence and testimony would end at 4 p.m. on Thursday, February 12th. The period for rebuttal testimony would end at 4 p.m. on Thursday, February 19th. And the applicant would have until 4 p.m. on Thursday, February 26th to submit their final legal argument. If the applicant doesn't choose to submit a final legal argument, they can let me know in writing, and I can notify the hearings officer so they can begin their decision earlier than that. And
Thank
that
you.
is all of my notes on that.
I'm sorry, I didn't mean to interrupt. Mr. Kovac, any comments?
No, sir.
All right, then just as to reiterate, the 7-day open record period for new evidence ends at 4 p.m. on February 12th, 2026. The 7-day rebuttal period ends at 4 p.m. on February 19th, and the 7-day applicant final argument ends at 4 p.m. on February 26th. Just as a request, I can't dictate this. If there's going to be a request to close the record early because of not wishing to make a final argument, I'd like that, just a request to be consistent in both cases so that it doesn't start my 21 days. And I do have discretion ultimately to decide whether or not it goes the full 7 days or shorter. I would prefer, just personally, if and when you do submit a final argument, or you decide you don't want to issue submit a final argument, that you let me know that clearly, that you don't need the rest of the time, and because I will close the record early if in fact the first day of the 7-day for the final argument, if you got it, submit it in both cases is my request, and then I will start issuing the decision. I will start working on my decision on that day. Any comments, Ms. Stewart?
No comments from staff.
Mr. Kovac, anything?
None. Thank you.
Okay. With that, then we'll close the oral portion of the hearing. I appreciate very much the testimony. Fair amount to read on this one. So I look forward to getting started. And as I indicated in my comments at the prior hearing, the more you can clarify exactly what you believe my obligation in these cases are, the clearer that sort of flow chart is, the more likely it is that I will be able to respond knowledgeably and effectively to your requests. So with that, we'll close the public hearing at this time. Thank you for your participation. Hearing's closed.